Okay, we're here with Judge Jennifer Robin, and we're vetting her for the Judicial Court number 410. With me, I'm John Wirtz, Vetting Committee Chair, MCTP. With me is Pat Tibbs, Brian Crumby, Del Fessenden, Ken Vaughn, Bob Bagley, and Larry Rogers. As we discussed, the process would be up to a 5-minute opening, and then we'll do about 45 minutes of Q&A, and then we'll close it out with your closing. And so we'll go from there.
Okay.
We'll just take it from there and then introduce yourself.
Well, I'm Jennifer Robin. I'm an associate judge right now at the 418th District Court, and I am the proven and committed and conservative candidate for this race. One of the things I'm going to point out now, and I'll say it again at the end of my little 5-minute spiel, is that I'm the only candidate in this race that has a board certification, and I'm the only candidate in this race that has 5 years of judicial experience. First of all, just a little bit about me. I'm from Montgomery County. I've lived here since I was 2 years old. I went to school from kindergarten all the way through high school graduation, with the exception of law school and college. I've lived here my entire life. I'm married a Montgomery County boy. We have twin 6-year-old children, Jake and Claire, and I've chosen to raise my family here. And I've been committed to this community and to the Republican Party for years and years now. I was in private practice for about 10 years before my appointment to the associate judge position. I'm one of only 12 attorneys in the entire county that's board certified in family law, and I've held that certification since 2007. I was handpicked by Judge Gilbert to be his associate judge. He came to me. I didn't go asking him for this job. He had asked the commissioners to open up the position of an associate judge position because of the demand for family law cases and the time demands that are involved with family law cases. And when the commissioners created that position, he handpicked me and said it was because he knew that I had the expertise as well as the temperament for this position. I've had the position for 5 years. I've never been reversed on appeal. I've heard bench trials, I've heard jury trials, and I've been experienced and I'm proven. Additionally, I have been, as I said, a prolific contributor to this county. Specifically, if you'll look at the cards that I brought today, the list goes on and on, but I've held many positions. Specifically within the last 10 months, I've started 2 high school Republican clubs, one at Montgomery High School recently in October. It was our first meeting. And last January, I started one in Willis High School. So I've been a strong contributor to this party, or to the Republican Party, and to this community. One of the reasons why I decided to, or some of the reasons why I decided to run for the 410th, and at this point in time, the incumbent has now announced that he is not running. At the time that I chose to run for this bench, that was not the case. And one thing I would point out is that at that time there were problems with that court. People knew about those problems. It was something that was costing taxpayers money, and it was egregious things were going on. And it wasn't until I challenged the incumbent and he backed out that anyone else jumped in this race. And the reason why I point that out is because it takes courage to be a judge. It takes courage to stare into the faces of people and render judgments against them and take their children or their property or their freedom away from them. And I've shown that I have that courage not only in the courtroom, but I have it outside of the courtroom in my actions. I believe that this court needs to have dockets every single day. I think that judges need to stay for full work days and move their cases. I do that over at the 418th now, and I would do that over at the 410th. I believe that judges should be available for law enforcement in emergency situations when they need reviewing of warrants. That's been a problem with this court. And also with voluntary review of blood warrants on holidays and no refusal weekends. Keeps our community safe, and judges don't get paid extra for it, but it's part of keeping our community safe, and I believe that a judge that sits on this bench should be doing that. I believe that I have the experience, the expertise, the temperament. I'm known for treating people in my courtroom with kindness and respect. I have control of my courtroom, make no mistake about that, but My belief is that when people come into the courtroom, it doesn't have to be a horrible experience where they're petrified and treated poorly and that sort of thing. If they want to challenge the courtroom, I'll be very quick to get control back, but I always start off by treating people kindly, and I think that's an important part. Temperament is an important part of this position. And again, I'm the only candidate in this race that is board certified in an area of law, and I'm also the only one with any, much less 5 years of judicial experience. Thank you.
Okay, great, thank you. How many, so the 410th is a general jurisdictional court,
Yes, sir.
and 418th is a family court.
Yes, sir.
How many people are in, I guess, in jail awaiting trial right now?
May I look?
No, sure, absolutely, absolutely.
The problem with the 410 right now, and one of the reasons why, and honestly, I have to point this out, this is not the best time of my life to run. I have 6-year-old twins at home. This was, I mean, I envisioned one day running for judge and not being an associate judge forever, but figured it would probably be several years down the road. The problem with this court, and one of the problems, is this issue about specialization. There are 12 courts in Montgomery County. This is the only court that refuses to go specialized. Now, when I say that, I want to be clear because there's been some misinformation put out there that I want to make this court a family law court, and that's all I want to make it. That is not correct. Family law is part of general civil law. It is civil law. And I believe that, and pretty much all of the judges on the Board of Judges believe that it should be a specialized civil law court. The problem is that the 410 won't relinquish the 11%, which is all it has, of all the felony cases. It's a small portion, and it's a drop in the bucket in the grand scheme of things, and we have 4 dedicated felony courts right now, criminal felony courts. The problem with that is it's leading to the lowest, lowest disposition rate on felony cases was in the 410th, and it was lower by about 16 points, with the next lowest being the 9th, and you all know what the problems are in the 9th District Court right now. So this was, I'm sorry, thank you so much, Barbara. I can't tell you, well, I can tell you this, as far as number of days, thank you, for, and this was 2014, I don't have the 15 data today, but I can tell you it's, average days to disposition for the 410th at felony was 147 days.
Okay.
And part of that, I guess I can't answer that now.
Okay. Okay. I'll come back because I have another question related to that.
That's you. You're passing me, okay. So, I take it from reading this that you're pretty much a rule follower.
Yes, sir.
You're very strict to rules, is
Yes,
what
sir.
how I read you.
Yes, sir.
And I guess, jumping that, what, is there anything that the government does, whether it's local, federal, state, that is more efficient than the private sector?
You got to understand that I have a pretty myopic view and that I came in thinking about the court. So I mean, as far as just generally speaking, I mean, I think that, you know, that competition, fair markets, I mean, I think that, you know, there's a lot of red tape in government. I think that there's a lot of efficiencies in the private sector. I mean, the job that I'm in is part of the government, so that's really all I came prepared to talk about today. But as far as just generally speaking, I mean, yeah, there's a lot of red tape with government. There's a lot of places where things can be, you know, I think that budgets can be tightened and things can be done more efficiently. But it's kind of part of as far as identifying specifically in the private sector, I can only generally say that there are definitely places where you can run a tighter ship if you have a private operation.
So your question number 12 about licensing
Yes, sir.
lawyers, barbers, that sort of stuff.
Yes, sir.
You quoted code, and then you said you trust kind of, it needs to be regulated by the government, licensed by the government, and it's important to maintain trust on the second part. So I guess my question is, how much do you trust government? How much can government be trusted? Is it getting to the point or beyond the point where it can't be trusted?
Oh, goodness. Wow, you ask really tough questions. I think that we have, as a society, I think we have to do things to try to restore public trust. I think with lawyers, specifically that question, we have rules of ethics, we have rules of disciplinary procedure that are in effect, with the whole idea that lawyers are supposed to report on other lawyers, and judges are supposed to report on other judges and other lawyers if there are things that are going wrong. As far as trust in the system, the idea is, for the self-reporting system, is that that when things are wrong, that they are reported and that disciplinary measures are taken, as far as lawyers and judges are concerned. Do I think that there are problems? Absolutely. And do people lose trust just because someone's licensed? Does that make them really good in the courtroom? Absolutely not. There's horrible, horrible lawyers that come in sometimes. But we have to have some measure or some standard, or else you have nothing. I don't know what else, I don't know what else there would be to do. Somebody's got to take some test. And the bar is a hard test. The bar is a 2.5, 3 day test. And so at least there's some measure, something to let us know that there's some minimum standard. Does that make them good in the courtroom? No. It takes experience and it takes studying.
So let me continue, and I'll give up my next question, if that's okay, just to pursue. So, I don't know if you're familiar with the recent election and the $500 million debt that was incurred. 2 people made the decision, really more than that made the decision, but 2 people got to vote on it because of gerrymandering at the legislature. And so, I'm at the point now where, our government is too much, where some people manipulate the system to get benefit for them, and then the other ones have to pay. And so to me, it's, so I don't, do you really, I'm not sure how to ask the question. Do you have that much trust? Where are you fed up? Are you fed up and want to change it?
Just in general with the government, where am I fed up with the government and want to change it?
Well, no, that's not the right.
We can talk forever.
Yeah, no, I understand that. It's like government has so much power.
Is it that question that, in particular, that my answer that bothered you? It's the statute itself, and you've got to understand, you mentioned I'm a rule follower, so I looked at the statute itself about the barbering, and that's what bothered me, was that the recent change had to do with that whole deal with hair braiding. And there was no reason in the world why we needed somebody to be licensed to braid hair. You can just undo it, wash your hair, and it
Right.
looks
Well, the
like
question
it did
was,
before.
should the state license it? Should they have the control of you can work and you can't work? Or should a private sector
And
be
I
better
stick
at that?
to, it may not be the answer that you like, I stick to my answer in this, that the way that it was, that statute was defined, barbering included hair braiding and anything else. I stick to my answer in the sense that this, on Saturday, I will go and get my hair cut, and someone's going to put color in my hair and cover up my grays. When they do that, I know who I'm going to. I know she's licensed. I've been going to her for 6 years or so. But when I first went to her, one thing that at least gave me some assurance is that she had passed some kind of licensing before she puts color in my hair. And I think whenever anyone's dealing with chemicals or anything like that, I think that's a little bit different than just, a haircut or a mustache trim. Right now, the way barbering is defined in that statute, it actually deals with any of those things, including coloring and chemical perming, any of those chemical things, and I think those people need education. I think that something has to be said. Does that make them good? Do the standards need to be better? Honestly, I'm not an expert in that field to say. I don't think government's perfect. I'm with you on that. I do like having some level of something before I walk in, knowing that somebody's at least had some education and had to pass some kind of test.
Can I pipe in on that one? If they're board certified by their own organizations, why wouldn't that be sufficient without the government coming in and dictating what they have to do?
Well, I mean, that's a different question. I mean, so.
Well, no, it's the same thing. I mean, if they certify, instead of the state certifying, it's certified within the Barbers Association or within the Realtors Association or whatever. It's not.
I don't have a problem with that.
Okay.
I mean, my issue is just I need to have some kind of level of expertise. I need something in there. Like for instance, the board certification test I took, I mean, it is governed by the Board of Law Examiner, so it's an institution of some sort that actually creates these exams, and they're very, very difficult, and you have to go through a very difficult process. If something like that was in place, and that's what we're talking about, and it was done through a private sector, I'm fine with that, absolutely. Just some standard. I'm not aware of any other alternative standards to which, but I'm not opposed to them.
Well, I mean, it's just like going to studying medicine. If you're not a doctor, but you can be a medical assistant, you get certified as a medical assistant, you take a test. It's not a state certification, but it still allows you to be able to do the job. You end up gaining experience and everything else after you've gotten that, but you've passed the test and you're qualified to do that. We're seeing this happen with plumbers. We're seeing it happen with different trades where now the state's deciding they want to get involved in it and start taking money for it, and they're the ones that are going to determine it. So again, it's the state getting into private business and dictating what private business can and can't do.
Is there a question in there?
No, it was,
But
so
just
your
simply,
feelings.
if there is a private entity that provides the same level of expertise standard, is that what you're asking me?
Right.
Would I be okay with that?
Right.
I mean, it would depend on the level of, I guess, of harm that could potentially be caused. For instance, when you talk about medical doctors, I mean, I guess, first of all, I'm answering without having any research at all. I'm not in medicine. I'm just answering to answer, because you're asking me. But, so this really isn't a very educated answer. But, and if I did some research, I could probably say something way better. But just off the cuff, I mean, if it's a hair cutting place and the hair people decide they're gonna have some privately created thing for certification, I'm fine with that. Great, wonderful. If it's someone that's about to do heart surgery on me, I may want to think twice about that. I would want to look into it first. I'd want to see exactly what you're talking about and what, that's just, it's the level of harm, I guess, is where it would go to.
Can we
Had to stand for
No,
Y'all are really worried about your haircuts, aren't you?
I'll explain later.
He gets them so seldom. Okay, the principle of nullification. I'm sure you understand the principle, and it could be applied in very, very many different ways, different locations. It can be applied all the way federal level, Supreme Court, whatever, all the way down to maybe your courtroom. So give me your thoughts on nullification. What are its pros? What are its cons? Is it a good idea, a bad idea? When should it be used? When should it not be used?
Well, I'm not sure if I really understand the question exactly. By nullification, are you talking about specifically with regard to laws? Is that what you're asking me? I mean, here's the way that I'm supposed to operate. The way that and that's really the only way that I can answer. In that I'm an expert in my little field. When y'all start going into other fields, my answers aren't going to be as good. I'll be honest with you, because I'm not. I know my job really well, and I'm prepared to answer it in terms of my job. As far as laws and statutes and that sort of thing, judges can't be policymakers. We can't be. We need to exercise judicial restraint. If there are issues that need to be changed with our laws, they need to be taken up with the legislators. And I have actually before gone to our legislators and said, hey, this is ridiculous. This needs to be changed. And people have brought it, and there was a small change to the family code last year because of that. So I mean, as far as my role in that, I mean, my job is to one, I have to look at the Constitution. 2, look at the statutes. 3, look at the case law from higher courts that interpret those statutes, and I have to apply the precedent to those things. Me going in and trying to do anything beyond that would be improper, and that's really the only way I can answer.
Okay, well, you're talking about the decision, trial by judge. What about trial by jury? If a jury foreman came out and you could see that they used the principle of nullification, you okay with that? Would you oppose that? How would you feel?
I mean, the jurors are given strict instructions before they go back there. If they do anything outside of the instructions that they are given, it's potentially grounds for appeal. So the first thing, as far as, I guess I can still answer this. So, I mean, we give them instructions, and these are the instructions that everybody gives in every single court. They give them to us because they don't want us to make any mistakes, and you read it off there so that you don't possibly bias a jury in any way, shape, or form, and you just read these instructions. And they go back there, and then they're given jury questions that we go over. And I know I'm not trying to, I'm preaching to the choir, you all know this, but I mean, as far as the process goes, we have pretrial conferences where we go over those jury questions, what's actually going to be sent back there and how they're asked. So I mean, as far as them being presented with certain issues and then answering those questions, I mean, their answer will say, do you find that so-and-so should be sole managing conservator? Answer yes or no. And so they have to answer yes or no. And then if yes, then, should they have a geographical restriction? Yes or no. And then they have to answer, so they are given very small areas to go in and do any nullification. I mean, they go back there, they deliberate, and they answer the questions as they are given to them. If they can't reach a verdict, then, they sometimes send out questions that we have to, and generally speaking, have to send them back to deliberate on. I've never had one, come to, we've never had a hung jury or anything. We've always had decisions, but I don't really know that they can. I don't know that they have that opportunity. If that makes sense.
All right. There have been several cases. I tend to say increasing number of cases, both nationally and in the state, related to children who have medical conditions. CPS comes in and says, well, the child should be taking this form of medical support. The parents are being inappropriate, even though they have their own doctors that are licensed dictating a different set of medical decisions. So when should the state be able to give CPS priority over the parents in that sort of situation?
I haven't personally seen that as a problem in Montgomery County. The only time, I mean, here's the deal. If the child is getting medical attention and is not being abused or neglected, then I don't believe that the state can come in and impose certain beliefs or anything like that on a family. The only time that I believe CPS should be involved is when children are being abused or neglected. And at that point in time, the goal is reunification. There's programs and plans that they set forth for the parents to try to go through whatever they think identifies the problems and what they can do to fix them. So with the whole idea of reunification. I mean, as far as the medical situation, I haven't seen that a problem here. And I've not seen it in my court. I've not seen that as a problem even as a practitioner, as an attorney. There have been problems in CPS. But I've not seen that with the medical issues so much. But I would definitely say that that's an issue for the parents as long as it's not resorting to neglect.
So who should be given the benefit of the doubt in the meantime?
Well, what do you mean by that? As far as whether children should be...
Well, the court process takes a year.
Well, the way that it works is, so for instance, in extreme situations, what will happen is I'll get an affidavit and an application. Can I go ahead and finish this one?
Yeah, absolutely.
Okay. I'll get, CPS will file something for, like, for instance, an emergency removal. what you just told me would not be grounds for an emergency removal. I would not sign an
Why does it
affidavit.
happen? I mean, it happens here in Montgomery County.
I have not signed one of those orders. I have
Okay.
not seen that personally.
That's
I'm
what all the
trusting
judges
you.
tell us, but.
Well, I'm trusting that that's happened because you're telling me that. I personally have not, and nor would I sign an affidavit like that. And when I get those affidavits for removal, I mean, I've handwritten before when there's something in the affidavit saying that there's a grandparent or someone around, rather than just taking them off to foster care, you know, picking up and sending them some stranger. I mean, whenever possible, until they can get to that hearing. I mean, I've handwritten in there, and with grandmother until hearing or whatever. If it appears from the affidavit that would be an appropriate situation. So I mean, I think the family needs ultimate control. I've not seen, I mean, when it's appropriate. Now, the things that I see, the things that come across my desk are horrible. Those are the ones that I'm seeing on these removal situations. They're horrible. They're hard to read. They'll give you nightmares at night. But I'm not really seeing anything about, and you wouldn't see anything about these emergency removal situations with medical decisions. Now, what you might see is if someone were to say that a child was being neglected for lack of medical attention or something like that, but CPS wouldn't just go and scoop them up. They might do an investigation. They'd have to then file for a case, and then they would have to, you know, set it for hearing and all of that. These emergency removal situations are, I mean, you've got to find some pretty bad facts to go and just have a kid whisked away, you know. So.
I don't know if I got mine or not still, or if I gave it up.
Ken, you're starting it when you started talking.
Yeah.
Number 16, how much of a problem is county hiring based on good old boy loyalty and leadership instead of one's ability? I read your answer, and I know you know of many cases where we've got a lot of family members that are hired, may or may not qualify. We get people that are getting ready to get fired from one precinct and another precinct hires them. That's the good old boy system that's taking place in this county. And not everybody goes through HR that's qualified.
Okay. And I'm not sure exactly, I think I might know who you're talking about. But, you know, my response was this, that I know that is something that's probably existed in the past. It sounds like you're telling me there's some specific examples right now that are going on. I mean, I can tell you in my court, there's not anything like that, so I'm going by my experience in my little vicinity.
Your little bubble.
Yeah, my little bubble. I'm not really talking about I mean, I answered the question the best that I knew how. And with that being said, I will say that, I mean, there are certain things on HR that they have to post job postings, they have to put the qualifications, there are certain things, not all of them, but there are certain, especially on the lower, like clerical type of positions, they've got to have certain qualifications. Things like that help. Does it fix the problem? Obviously no, if you're saying that there's some of these situations going on. Additionally, I mean, I think just you bringing this up, that was part of my answer. It's people's jobs in this community, if you know something like that, to bring it to the forefront of people's attention. And I think that is a deterrent for an elected official to make those kinds of decisions when they think they're going to have the whistle blown on them.
I don't see it happening in the courts as much as I see it
Yeah, I don't see
outside
it
of
too
it.
much.
The courts has its own problem with politics.
It does, yeah. I mean, I feel like I'm in a pretty good situation, but I wouldn't be running right now if I didn't think there was problems, so.
Okay, you've been in family law 10 years,
Yes, sir.
and then 5 years judicial, so it's 15 years total?
Yes, sir.
Okay. Becoming a judge, well, explain to me the difference in an associate judge and a judge.
I'm glad you asked that because people really don't know that very well. So first of all, I was the first associate judge in Montgomery County of its type. We have our 4D, which is, you know, our AG court judges that have been there for a long, long time. My section that I'm under is Chapter 201 of the Family Code, because the 418th is a dedicated family law court, and all of my powers and duties are set forth in Chapter 201. Basically, the idea about these associate judges, and you see them especially in these larger counties, like you see them in Tarrant County, Harris County, Dallas County, I mean, all of them. You'll see it in all these larger counties, because you can essentially have you can have two people moving cases with less court staff. So although I have a bailiff and a court reporter, I don't have my own court coordinator. I don't have my own other set of offices. We have one little metroplex of people doing the paperwork, and then we've got 2 courtrooms running. So the idea is it saves the county money from rather than creating a whole new county court at law or something like that, or going to the legislature and asking them to create a whole other court. So basically, my abilities under the Family Code, as an associate judge, I basically hear everything. There are a couple of things that I'm not allowed to hear. One of those things is the judicial bypass statutes. That is reserved for the elected judge. Used to be name changes. That was actually what I brought to the legislature. It was so silly. I can change a name during an adoption or when you're getting married, but I couldn't do just regular name changes. And I went to the family law group, and I just said, that's crazy. I'm allowed to take someone's kids away, but I can't change their name. That just doesn't make sense. So that was recently changed, but that was in the same chapter as the judicial bypass, and I think it just had all gotten lumped together, and that's how it ended up that way. We fixed that problem. But essentially, what we do in this court, and I'll try to be really quick, what we do in this court, the statutes say this: nobody can object to me on a temporary order. If Judge Gilbert assigns a case to me and it's a temporary order case, you can't object to me hearing that case. They can de novo the case if they don't like my decision, which means that they have 3 days to then request it back up to Judge Gilbert to review the decision. What we do, because we don't want to hear cases twice in the 418th, the whole idea is to move cases, not hear them 2 times over. So what we do is when cases come up, he'll say, okay, do you waive objection in de novo? Yes. Okay, great, go to the associate judge. And so everything I hear, everything's been waived, and the de novo's been waived. So we never have, I think maybe once or twice in 5 years have we ever, just because of in the judicial economy, there was, just the case needed to be heard, and it's one of those deals where sometimes people will do it to try to not have to go to, if they think Judge Gilbert's busy and they don't want to go that day, they'll object to me trying to not have to go that day. So Judge Gilbert made him hear it. He made me hear it.
So an associate judge is appointed, are you appointed yearly, 2 years, 5 years? What?
I'm appointed for the length of the term of the judge who appointed me. So I was sworn in on January 1st, 2011, when Judge Gilbert was reelected in, was that in 2012? I was re-sworn in on January 1st, 2013, I think. So.
And I know we're over time. Running for this position, will you benefit financially a great deal, small amount, or not the same as you're benefiting now?
When I took this job as associate judge, I took about a $40,000 pay cut. I took it because, it sounds crazy, but I took it because, I think, have you ever heard of Maslow's hierarchy of needs? You've got your basic needs: food, clothing, shelter, and and at the very top is oh gosh, I was thinking of the word.
Self-actualization.
Thank you, self-actualization. And I have I have a husband that's got a good job, and I've got great children at home, and we have a good family. And this opportunity came to me. Judge Gilbert came to me, and it was, when you love law, when you love what you do, this is the next step. It was an exciting opportunity for me, and I took a pay cut for that. Going up to the next level, I started out at one number. It has increased since then to be more in line with other associate judges in other counties. So it's I think I may be around. I think I'm around either 113 or 1, somewhere around there. Now I started out at 100,000.
Are associate judges strictly for family practice or?
No, in fact, now we have two other associate judges. One of them is shared between all of the felony courts, all the criminal courts. And so he actually goes and he just hears he hears all of their, anything they want to assign to him. I'm assigned strictly to the 418th, and County Court Law Number 3 has, which is also a family law court, also has one strictly assigned to them. But other counties that are larger than us, they have them in civil, just general civil, they have them in criminal, all over.
Great.
Okay, and in my first question, and I was asking about how many were in jail, you know, how many inmates are in jail right now, obviously going through the criminal court system. Okay, so, and you touched on the fact that we had heard that there was a rumor circulating that if you're elected to that court, the 410th, that maybe not you, but the Board of Judges in Montgomery County would turn your court into a family law court instead of a general law court. And is that what I guess you were alluding to, and because you were saying that you
There's
didn't.
misinformation
that
out
wouldn't
there.
happen. Okay.
Well,
And so if that happened, what if the Board of Judges decided to do that? Do you have a say in that?
so the answer to that question is this. I'm going to do whatever is best for this county. If this county and the Board of Judges says you need to keep that 11% of criminal felony cases, hear criminal cases 1 week out of the month, and not hear them again for another 4 weeks, which to me is ridiculous. But if that's what this county wants me to do, then I'm on board. I'm going to do whatever is best for this county. The Board of Judges makes those decisions. I would be on the Board of Judges if I get elected to the 410th, so I would have some say in it. I mean, I think what has to happen, and I think what they've been doing for probably about a year and a half now, is they've been reviewing the numbers and seeing what the needs of the county are. The needs of the county are changing rapidly with Exxon and with all the. I mean, this county has been exponentially growing for many, many years. But it's seeing great growth, and so I think they're keeping an eye on the numbers. Whether that stays, right now, to me the numbers say it stays general civil. That's what, to me, it says. Whatever the numbers would indicate, you know, I'm on, my job is to move cases and to be efficient in this county, and that's my position.
Mm-hmm. Okay, so in this same question, number 3, qualifications and experience to make you the best candidate. You had mentioned a large part of the 410's case load is comprised of family law cases. What is that percent?
It is, now, this is 2014, and the numbers have changed because the amount of criminal that the 410th took went down in 2015, in August of 2015. It went all the way down to that 11% that I was talking about. So these numbers are a little bit skewed, but the family law, approximately family law in 2014 would have been about 35%.
Okay. All right. Okay. Thank you.
Okay, as you know, the 9 Supreme Court justices have made some controversial statements and decisions on law. Which of those do you disagree with most, and why?
Well, I mean, the one that touches me the most is the Obergefell versus Hodges decision. Obviously, that's the one that's going to affect, and that's another reason why, actually, to kind of go back to what he just asked me, that also opens a whole new slew of cases that we haven't seen before. We've already gotten some. So same-sex marriage means same-sex custody cases, which means same-sex divorces. It means a lot of different things that we didn't have before. So we're about to have a huge influx of more family law cases. You know, I have friends, I have a friend that I like and that may see this video one day, and he is gay, and he got married, I think, in Hawaii or something, and came back, and, you know, I guess now, I don't know if they're ever gonna redo it here in Texas. I mean, I don't want to, I'm not about being mean about anybody else, but I do have a belief in what marriage means, and that it's between a man and a woman. The Obergefell decision, was really about the 14th Amendment and about whether or not, states had to issue licenses, marriage licenses, and whether it had to be recognized by all the other states. I liked the way things were before, where it was an issue of public policy for the state to decide as to whether they would honor or give reciprocity to other states' decisions. I don't like what's happened, and that's been the most difficult thing.
Okay, well, referring to some degree back to question number 3. As I read through your answers, clearly you're certified in family law, and that is your specialty. That's what you've been practicing in your private practice as an associate judge. And this court is going to hear a more broader range of cases. So could you explain, first of all, explain a little bit more your qualifications to hear the cases other than family law? And second of all, you made a point in question number 3, you've never been reversed. What are we talking about? Are we talking about 5 cases, 500 cases, 5,000 cases with no reversals? You have to give us a feel for that.
I haven't, the number, I can't tell you. I think it's under 10 that I've actually been appealed on. I would say probably closer to maybe 5 in 5 years. I mean, I think that when you follow the law and you aren't going off course, the likelihood of people pursuing an appeal gets limited. And so in those limited situations when I have been appealed, I've never been reversed. Because I am a rule follower. I believe that my job is to apply the law as it's written. And as far as my experience goes and how that translates, first of all, again, the numbers are a little bit skewed, but in 2014, the 410th had about 24% of just general civil cases, or 24% of its caseload was general civil. But here's the thing, general civil, family is civil. Okay, and so every day I'm applying the rules of evidence, applying the rules of procedure, rules of discovery, decisions about discovery come before me on a daily basis. These are the same rules that apply on all the cases. The running a jury trial, running a bench trial, all those things are the very same thing. In addition, what's different about family law that's not true about other areas of civil law is that they have crossover topics. And what I mean by that is, for example, a lot of issues, property issues are involved in divorce cases, oil and gas, bankruptcy. I have a lot of contract law issues that come before me, complex contract law issues, business entities. I deal with experts on a routine basis, and as far as qualification and whether they're being excluded at trial. All of these things I see and I will continue to see in a general civil courts. I'm ready for that. I had some experience before. My expertise is family law. There's no doubt that is my area. But I did do some other than that, small bit other than that in prior to my appointment. But those crossover topics are all every day.
Okay, thank you.
Right. We're at a point, let's see, 5 minutes. I think we might be able to.
Okay, finish the rotation.
Going back to the nullification issue. So what happens if the Supreme Court comes off with ruling that essentially says, yes, the IRS, if they investigate you, they can say you don't have the right to own gun ownership or something along these lines. And then someone challenges that in your court. And they're arrested for that. They're brought to you. I mean, do you uphold that law that is clearly unconstitutional because the Supreme Court said it?
Can you state that again and then start your
Yeah.
clock
That's right.
after you
Yeah.
finish the question?
Susan, that used to be a time out.
And I need, before you answer that, when the Supreme Court makes a ruling, it's not a law. The legislature is the only one that can make the law.
Yes.
All they can do is interpret it. That doesn't make it law just because they came down with that.
What they did with Obergefell, they made a law.
So your question is whether or not I would hold someone to a criminal standard because they violated a law that I didn't necessarily agree with? Is that what you're basically asking?
Violated a Supreme Court ruling
The Supreme Court violated the U.S.
that
Constitution.
violates the Constitution, but they're following the Constitution.
And what is their, okay, and just so I can be clear, what is their ruling that you're hypothetically telling me that they took the Second Amendment and they decided what, that it meant what? Because what they did with the Obergefell.
If you're under investigation,
Uh-huh.
that you're now a danger potentially to someone who's investigating you, and therefore your right to gun ownership can be taken away while you're under investigation. So they're basically saying you're guilty till proven innocent.
I'm sure you've seen the news articles about senior citizens who require financial assistance, not, handling their finances, about veterans that may have PSTD, whether they're qualified to own guns or not. That's current news.
Right. So, first of all, to some extent, I agree with Bob in the sense that the details of your hypothetical, that's more than just an interpretation of what the Second Amendment means. That's actually coming up with a statute essentially, and I don't think that they can do that. Let me just say this. The rules of ethics require that I can't comment on how I would rule in a case in the future. That's canon number 5 of the rules of ethics. So I can't tell you precisely an answer to that without violating the rules.
Okay.
But I will say this. I do believe that, that first of all, I think the hypothetical would be seen more in a statutory situation from the legislature. Regardless of who it came from, my job as a judge is to take the law as it's given to me. If our legislators go in and this is what they come back with and I'm not happy about it, I don't get a choice in that, and I don't think you want me to be sitting there and legislating from the bench. It's a problem when they do that. That's what's happening in some other courts that we all know of. And so to answer your question, if a statute is written in a certain way, I'm going to follow that statute. If the U.S. Supreme Court came in and started to encroach on Second Amendment rights, which, by the way, I have my concealed handgun license, and I am extremely happy as a barely 5 foot female, happy about this open carry thing because I can't conceal a handgun on me. I am thrilled about that, and I'm a staunch supporter of that. But what is my job as a judge is to follow the law as it's written, and that's what I would do. And anything else, privately, I might go to my legislators, I might go and I might join groups and whatnot to try to change things, but as my job, I have to do certain things.
I think part of the problem was the Supreme Court, when they set something down, it's not a law, it's a ruling. It's their rule that they came up with, but it's not a law. And judges, people, shouldn't be taking their information and making it law if it violates the U.S. Constitution.
So what
Basically.
you're saying is the perception is after it's done with the Supreme Court, it becomes law. Perception.
That's the perception that people have, but that's not law.
So what's the judge to do?
I don't know if you look at
Well,
question number,
It sets a precedence, but then again, if it contradicts what the Constitution is, aren't you duty bound to follow the Constitution and not necessarily their will? And because you can do that. Is prime example.
Is the example, and my rules of ethics and the rules that are required of judges, because the danger is this. On one hand, I think people want. I think you want me to say maybe that stand up for what you believe in, and okay, but the problem with that is when people do that and it's not the same belief that maybe another person has, then we've got people who are doing things that they shouldn't be doing. And either way, we've got to have somebody who's impartial, who is just applying the law as it's written. The problem is it can't start there. We've got to have the people in the legislators, in the positions, appointing the right justices, doing the things that are necessary to make sure that our beliefs are perpetuated all the way down the line. But Obergefell, I can't just decide tomorrow that, well, that violates my principles, so I'm not going to allow you to get your divorce because I don't believe you were ever married. I can't do that.
We're not asking your principles,
Principles.
we're asking the
Constitution.
Constitution, not your feelings, not
Which
your,
takes priority?
what takes
Case
priority.
law or the Constitution?
Right.
Yeah, strictly Constitution, it's not what you feel or principles from that standpoint.
I know it's hard for you to answer, but that's where,
Okay, so the way that we are supposed to handle it, and the way that we're told to handle it by rules of ethics and otherwise, is that it starts with the Constitution, goes to statutes. Case law is supposed to interpret, not change, but interpret.
Supposed to.
Supposed to, and that's what that's what's supposed to happen. But to answer your question, as far as am I going to not follow the law as it's handed down to me from the U.S. Supreme Court, which it does, they do create law in the sense that they interpret the law. That's the problem. And if you don't like their interpretation, they've just created a new one. So, for instance, Obergefell was an interpretation of the 14th Amendment, but it's just created some new law for us. So, essentially. So, the answer is this: I have to follow precedent. That's what my job is. And to go outside of that, I think you start to get into a really dangerous situation if you have judges that are doing that. The problem has to be fixed elsewhere. In the judicial capacity, you have to follow the law, and you have to follow precedent.
So who carry the precedents, you or the Supreme Court in that case?
The U.S. Supreme Court has.
They can't create a law. Okay.
Well, and neither can I. But
Somebody's going to win. It's a tug of war.
Yeah, but you have more
we all
standing,
agree on the same thing. The only difference is that I am. I'm sorry.
Doesn't sound like it.
Okay. Well, okay. So what I meant was I think we all agree that Obergefell was inappropriate. That's what I meant. As far as what I can do about it and what y'all believe I can do about it, that may be a differing opinion. But I believe that I have certain judicial ethics that I have to follow, and it limits what I can do.
We'll bring us back to Montgomery County.
Last question. Pithy.
The indigent person that comes into court, how are the lawyers appointed for him?
Well, in family law, the only time that they get appointed lawyers is if there is the possibility of contempt, criminal contempt. In other words, the only time we ever see those are enforcement cases where someone is saying that someone violated a court order. And then they would have a right to an attorney if they are found indigent. The first thing they have to do is file a sworn affidavit of indigency where they say, what income they make, what benefits they receive, all of that stuff, what their expenses are, the whole bit. Then we have an indigency hearing to determine whether or not they actually are indigent.
So it's not that board of indigent.
Defense people, no.
But it's not just a
Well,
form they fill out and they don't case it.
No. In family law, you don't have a right to an attorney. The only time you do is if there's a possibility of jail.
Because that's criminal versus civil. Okay, so we're at the point of closing, unless you want us to keep going around the table and exhaust your 5 minutes. Maybe not, right? That's up to you. You want to go ahead and do your final closing, and then we'll wrap it up.
I would just say that, this has been a rough hour.
Good.
I respect what y'all do. I appreciate the opportunity to be here tonight. I hope that I've proven, you know, even if my answers weren't exactly what you wanted or exactly how you feel, I hope that I've proven that at least you're not going to get someone who is going to go in there and do off-the-wall decisions, make choices that are going to be not only an embarrassment for our county, but also costly for the county. You know what you're going to get with me, because I've been doing this for 5 years, and I've been steady. You don't ever hear about me. You probably didn't even know there was an associate judge for a while there. Because I just go in, I do my job, I do it quietly, and I go to work, and I follow the law, and you don't ever hear about me, and that's a good thing. I'm not looking for fame and glory. I'm just going in to do the job. So I hope that I can earn your support. This is important to me, and like I said, I'm the only one with the board certification in any field, and I'm the only one with judicial experience, and you know what you're getting. So,
Okay, great.
thank you so much. Okay.